Hello, everyone, and thank you for joining us at another roundtable discussion. And our topic for today is pensions to divide or not to divide. Um, for most families in Ontario, the matrimonial home and the pensions are the two biggest assets that they have, and how those assets are dealt with can have a huge effect on the parties, both in terms of retirement planning and in present cash flow. So today we want to talk about how the pensions will affect parties, and we're going to be dealing with common law spouses. We're going to be dealing with people that are married, and you're going to have the opportunity to hear from two experienced lawyers who work on these issues every day. And we've given them positions. Okay, obviously, they're not set with these positions. In fact, in some cases, especially with Anisa here today, she knows she's going to be making very creative arguments. Okay, let's just put it that way. But the point is, whatever your situation is, when you come into our firm, we work for you. We work with what your best interest is. But for today, Anissa is going to be taking the position that the pension should not be divided, and Sherine saying it should be divided, while I will just be asking them some tough questions to test their positions. So I guess let's get started with Anisa. So if we have Jane and John, and amongst, and they own, in this scenario, they own a matrimonial home and they own a pension and nothing else. And they've recently separated, and they're trying to deal with the equalization of their net family properties. And who would have you represent Jane? And Jane has a pension that she doesn't want to divide. Give us an intro.
Okay, so I think for an intro, basically what for everyone's benefit is kind of what is the pension? The pension is a type of retirement plan. It provides monthly income in retirement. What I don't know about Jane and John, Angela, you can help me with that, is how old are they? How long have they been married? A little bit more context. But before that, just not everyone has a pension. And I think that it's something that if you do have a pension, great, especially in this economic state that we're in, specifically with Jane and John. And historically, a lot of times I'm assuming they're married, right?
Yes, so let's assume they're married now.
The husband usually was kind of that breadwinner historically. So this is kind of, even though it's been like this for so many years, this is still new stuff. We're seeing a lot of women who are more financially stronger, both currently and in retirement. And my position is that sometimes the law actually doesn't adequately support that right now. But I'm sure it's changing, it's evolving. I mean, there was a change to the Pension Benefits Act in January 2012. So there's lots coming from that.
Okay. And so, Sherine, just as an intro, what can you're in this case John's lawyer, and he doesn't have a pension. And to add a little bit more context, and just for our viewers, I want you to know that they don't have the fact scenarios. I'm making it up as I go along, and there's a reason, because sometimes when our clients come to us, the facts are not clear. There's little bits and pieces. Even the owner of the pension, sometimes they don't understand the extent of the asset that they have and things like that. So things evolve with family law matters, and I want to keep them on their toes, so that if you do speak to them about your matters, that they can answer any questions you have on the fly. So let's give Jane and John ages. Okay, so we have Jane as, let's make Jane 45, and let's have John at 50. And don't be surprised if we change that up later, but that's where we're going to start now. So Sherine, can you give us an intro on, John comes to meet you, has no pension, and he's 50 years old.
Okay, well, thank you. So John, essentially, because he isn't the one with the pension, I can automatically tell him, because he's married, he's automatically entitled to a division of that pension upon the breakdown of their marriage. So, and that would all form part of equalization. There are other aspects that I think we'll talk about today as to when it wouldn't form part of equalization, or when it should be divided in addition to other ways that it can be divided. But with John specifically, I would say that he would be entitled to a division of the pension automatically, and that value he would be entitled to based on the period that they've been married to the time of separation, and that would be that would form part of evaluating what that pension entitlement is. There are other ways to value pensions, I'm sure we'll discuss too. So there are different pensions and different ways to value those pensions. But for John, ultimately, I would just be relying on the law, and that automatically he would be entitled to a division of that asset.
Okay, that's a good one. Yes, because ultimately it is the law that pensions have to be valued, but sometimes we have to be creative in coming up with solutions for our clients. We may not be able to, sidestep the law fully, but we may be able to find ways to help our clients accomplish what they want. And Anisa, I know you had added that you had asked what the length of the marriage is. So we're saying 20, let's say they were married for 20 years.
Okay.
So we're looking at a relatively long-term marriage. Can you see any way, sorry?
Any kids?
Yeah, let's give them 2 children. And they're, 16 and 18-year-old. So could you see any scenario where, in this case, where Jane could get away with not splitting her pension with John?
So, as my colleague said, for married spouses, the automatic entitlement is to split your pension. It forms part of equalization. For couples who are married, the process of dividing family property between them is called equalization, and it's a 2-stage process. Part of that is to calculate the net family property, and then subtract the debts, and then divide basically what the increase of family property is equally amongst them. Pensions, what a lot of people don't understand is pension is property. It's treated as a piece of property, in as much as it's not available right now, especially for Jane. It's not available to her right now. It's something that for her, it's great that she has a pension, but it's not, she can't go to the grocery store and use it right now, right? And then when she actually needs it, she will actually need it. And so with regards to not dividing the pension, and back to your question, Angela, for her not to divide her pension, the creative ways that we use in practice as lawyers, if she doesn't want to divide it at source, so at her pension provider, which means that when she is eligible to collect her pension, she would get less, basically.
Yes.
Ways around that is, you had mentioned that they have a matrimonial home. So if their main assets are the pension and matrimonial home, we're dealing with 2 pieces of property.
Yes.
Matrimonial home is treated a little differently, but if they're dividing that home, and I'm assuming since, and I'm just inferring here, they've been married for 20 years, they've made maybe some strong financial decisions. I'm assuming there's equity in this home, right? Let's even pretend they've lived in this home for 20 years.
Okay.
Or even 15, but there's a lot of equity in the home. If not, maybe it's even paid off, but there's money to play with in the home. There's equity to pay with. So instead of splitting that home down the center 50-50, if Jane wants to keep her pension at source, so to give her more money when she retires, she would basically be giving John more of the equity from the home when they either choose to sell it or there's a transfer or anything like that. So that's one way to do that. Or if there are any other assets, to kind of set it off and pay from the other assets, whether it's a spousal rollover or even cashing in her RSPs, or if she has mutual funds or stocks, bonds, etc. If she really wants to sell her own items too, frankly, right? That's another way. There are other creative ways as well that we can deal with it. If she doesn't, let's say she doesn't have equity in the home, and let's say she doesn't want to divide it at source, right? That's something that we see a lot.
Okay.
What do we do? And there's no golden rule.
But I'm gonna jump in there because you've made Sherine's job really easy. So on the one hand, she's happy that you've considered that the pension is property to be divided, and that's fantastic, right? There's nothing more. At least you guys have a common base where you're starting out. It's property. It's going to be divided, and now you're at how do you divide it? So you've touched on a few things, and I want to give Sherine a chance to talk about that, because let's say. So we're looking at, we're going to talk about this from 2 angles. So let's say matrimonial home is paid off and there's lots of equity in the home that it could pay off this asset. So that's one. And after that, I'm going to touch on with if there's no equity. So let's imagine there's equity to be paid off. What would you tell your client? Would you automatically agree that, okay, you know what, you just get paid out from, Jane doesn't want to divide her pensions at source. No, actually, I want to get this straight. So Jane has the pension, doesn't want to transfer to John, and she wants to give John, I guess, cash from the matrimonial home. Okay, is that something that you would be comfortable agreeing to?
I mean, if it's divided at source, I mean, there are, again, so you indicate that there's not going to be enough available for her upon retirement if she divides it at source, or if she uses proceeds to pay him out instead. Are these proceeds significant to the exact value of the pension?
Yes, so let's say they are. Now, actually, I'll take that back to you, Anita, because what if your scenario is imagining there's enough to pay out, and I'm just going to imagine, Sherine, that you probably don't care if your client gets if your client's entitled to $400,000 and they get it by way of a transfer to John's, to a lira for John, or if he gets it through cash from the home, your client's fine. Like you're just gonna sit and wait for Jane to figure out whatever she wants to do. Is that a fair comment?
Yeah, well, I mean, given that John is about 50 years of age, if one of the eligible options usually are to be able to transfer into a lira, which you can access at the age of 55. So
Okay.
if he's dividing at source instead of getting the proceeds directly, then obviously it's a better windfall for him in terms of, because he'll have to wait 5 years to be able to access that capital. So if he's getting it straight from the proceeds, then again, fine. It really is what works in his best interest. In that scenario, yes. If there isn't enough equity to satisfy the payment owing, then no, then it wouldn't make sense, because within 5 years he'd be able to access that capital upon retirement.
Okay, so now with Jane, do you think that's a good idea for Jane to pay out of the matrimonial home, considering she might, if that's going to swallow up all of the equity she has? So what about cash for Jane? How are you going to deal with that?
Oh, it's horrible, because if Jane is relying, if her main asset, for a lot of people, the main asset is the home, because that's equity that they, for the most part, they can actually access and use.
Yes.
And choose whatever they want to do with it, right? The home is security, and her pension, right? So for a lot of other for a lot of other people, it's the matrimonial home and their pension if they have it.
Yes.
If her dividing her pension, and let's go for the big guys, if she has a hoop pension or an Omer's pension or even a teacher's pension, that's going to be a lot of money.
Yes. So what is she going to do? Because she's going to be cash poor.
She's going to be cash poor, but asset rich, and that's a decision that Jane really has to make as her legal counsel. I would let her know what the implications are. But if she's, for example, if she can't come up with a financial plan to pay out John, to keep her assets still intact at source, her pension still intact, then we have to face the reality of the fact that opposing counsel is going to say, well, the asset's there, let's divide it at source. Your client really can't choose here. But that's when we have to be creative and we have to come to solutions. So if there's not enough money in the home to pay out, or if it's really going to cause her detriment financially, and like I said, there's no golden rule. It's kind of what we can agree to, what's in the best interest of both parties. And again, the kids is another point, because we have a 16-year-old. The 18-year-old not so much, but we have a 16-year-old who may need that, and both of them are also going to post-secondary and things like that. And,
yes.
And I'm not even getting to kind of what their residency arrangements are. But there could be ways for Jane to maybe come up with a plan financially, because here's the deal. At the end of the day, yeah, we could divide at source. John puts it into a lira, accesses it in 5 years, or if there's equity in the home, gets paid out immediately, and he can do whatever he wants. But if there's not enough, she doesn't want to divide it at source, there's not enough in the matrimonial home to pay out, I would say let's come up with a financial plan that can help her in the immediate term, and maybe give John the equity, give John his share of the pension a little sooner, also without having to lock it into a lira. Maybe he can access it at 53. Maybe it's a 3-year plan.
Okay, so what are you proposing? So what would be the plan? Because it sounds like, so now we've moved to the scenario where there's not enough money to pay out. But again, I think I just want to wrap up where we were with having enough funds to pay out, is your position, well, Jane is either going to accept that, she has to pay him out the equity and just be cash flow poor so that she can have that benefit of the pension in the future. Okay. And you touched on a payment plan in the event that there is not enough money for, from the home to pay out John right away. What's your take on that, Sherine?
So I would disagree. I mean, a payment plan wouldn't suffice. So
Why?
I would see,
Yeah.
given the fact that if he were just to divide it at source, and he would have access to half that value within 5 years and the full value. Again, you said that there's not assets. I guess the 3-year payment plan would suffice if it was only a 3-year payment plan. Anything longer than that period, then again, the same scenario applies. It wouldn't benefit him, given that he would automatically receive that lump sum into one of the different options that are available through the pension plan administrator. And given that it should be divided at source, and the law indicates that if they'll take into consideration the different assets that are available in order to determine whether or not it should be divided at source. In this case, if there aren't significant assets in order to satisfy that payment, then I would argue that it would be divided at source.
And could you possibly sell to your client the fact that, the pension is a retirement asset, it's created for retirement purposes, and so maybe she should, it's the law that those are the factors that a court would take into consideration. So is that something that, would you be willing to present to your client that, well, it is for retirement, allow him to get that pension for retirement?
I mean, I'm gonna have to, right? Because look at how the courts are, and it's one thing to see the law and interpret it in 1,000 different ways that I can sell to her in my opinion, right? Because lawyers were like doctors, right? So we can sell kind of whatever we want that can make sense and might work. But if I'm dealing with opposing counsel as proficient as my colleague here, they very well are in their rights to refuse, because for John, I see it from the other side too, and that's a reality of the situation. I mean, perfect world, John agrees to us, right? Yeah. John trusts the fact that Jane's going to pay him out in 3 years or 3.5 years, and it is what it is, and they're going to have those loose ends, right? But some people don't want loose ends. No. The courts aren't a fan of loose ends, and especially when let's say this actually gets to a trial. I mean, Jane's gonna have a really hard time not automatically dividing that pension at source, because that's what it's there for. That's the law, the default of the law. And I have a lot on kind of maybe what the law should change to. Prepared for this round table today.
Oh, I would love to hear that.
So I'm ready. Let's do this. But since we're talking about within current day situation,
okay.
She may just have to agree, right? If Sherine brings a motion against us, and let's say it's the only issue, it's a summary judgment motion to settle everything, I can't really see, except in everything's case by case, but I can't really see, based on what we've dealt with and case law and the law, that Jane really would kind of be successful if that pension is there to be divided, and it's security, right? Because what if she stops her payment plan? What if she's unreliable? What if she picks up and leaves?
I mean, you could put those into you could write those into your kind of write those into your agreement, though. But there's also things like taxes that I wanted you guys to think about, and how would that. So we know that there's contingent taxes on those assets, and I wonder if that would be a factor. Actually, Sherine, why don't you talk to us a little bit about what contingent taxes are and how it applies to pensions?
So contingent taxes are essentially taxes that are at a future tax rate that they'll be taxed at based on the amount that's being taken out. So they're there to just kind of put a mind to the fact that at the time that you're going to remove these funds, there will be tax consequences.
Okay.
So if you do have a pension, if you're not dividing at source, for the most part, you can deduct notional disposition costs, notional taxes, because those will factor in whether or not, and that would reduce the asset too. and that would be beneficial for Jane in this.
It might make
in this
it easier
instance.
for
Yes.
Jane to pay. Okay.
So it would reduce the asset quite a few, depending on her marginal tax rate as well. So that would actually have to be taken into consideration.
Okay.
And so sorry, what was the second part?
No, I think you actually. I just
did,
wanted
yeah,
you
you
to
did,
explain
yeah.
the contingent taxes for us, and you actually did. So yes, so that, and then Sherine is right. That might work out in Jane's favor, where if those contingent taxes are taken in, it might reduce the amount that she has to pay out at source. So as you can tell, these are not easy questions. It's not it's never as black and white as it seems, because yes, we all recognize what the law is. It is property to be equalized, but the law doesn't give us straight answers when it comes to how we can deal with our client specific situations. So now I'm going to flip it. So let's say Jane in this situation is the one that didn't want to divide her pension at source, but let's say Jane does. Let's say now Jane is saying, well, I want to give him the pension at source because I want I need this $400,000 equity from the home because I want to put a down payment on a home. And John is saying, well, I have very little funds. The spousal support I'm going to be getting is very little, so I can't afford a huge mortgage. I don't want that pension going, being put in a lira that I can't touch for another 5 years. I want to maximize the amount I put down as a down payment. So I want Jane to pay me out from the matrimonial home. How interesting will that get?
I mean, it's definitely an option. So if there are assets readily available, yes. I mean, it forms part of equalization. So if the equalization amount is there and you have assets to satisfy that equalization amount, then you should pay it. I mean, again,
isn't Sherine fantastic? See, this is what we do every day. I just flipped the position, and she's just almost as passionately arguing the other side as she did, which is great. Yeah, I like your thinking, Sherine.
Yeah. So I mean, if it's available, again, the courts will have to consider if you're the one who now wants to divide it at source and saying it shouldn't be an equalization payment and then there's assets that are readily available. Your position would have to be, that dividing it at source is the most appropriate given the circumstances of each party. In this case, I would say no. If there's assets available, then it would make more sense given the liquidity of cash that is available to John in this instance. I would say he would have that the proceeds would be that would make the most sense for him.
Okay.
Yeah.
So what would you do for Jane? What arguments would you have against that?
Just because there are assets to satisfy that. I mean, at the end of the day, again, now she's cash poor, asset rich. She can't touch that. And Jane's also 5 years younger than John. So
yes.
Whereas he could access the pension in 5 years, she has 10 years.
And probably can't even access it as a lump sum actually, because let's imagine it's a defined benefit plan, then yes, she gets a lot of income at some point in the future, and he doesn't. Now, there's something that I always also think about when we're thinking division of pensions, and I notice that a lot of my colleagues don't think about this, is the fact that we're dividing an asset now that there's a potential that neither party actually gets. Because for Jane, she has the biggest risk. So I would try to leverage, if I get the sense that John really wants this money, because for him it's very important that he has, he can buy a home, and given the prices of home in the GTA, if he's on a limited income, then I can see how it's important for him to put down as much on that home. I would want to leverage, I would want to discount what I give him a lot, because I'm sure a long time ago these never happened. People had a defined benefit plan, and they got the plan. But we also, I believe it was last year, a couple of years ago, a company like Sears go under. People's pensions wiped off, and I'm positive as the years go by that lots of pensions are going to be wiped off over the years. So Jane, that's probably an option for Jane as well, to discount that pension significantly, because John gets the immediate benefit guarantee of knowing that he has cash at hand to go invest in a new home, while Jane bears the full risk of that pension never ever vesting. Is that a fair comment to make?
It's definitely fair, but it also comes to, in this scenario, and my argument to my fellow opposing counsel would be, all they came in with, because all we were given was that they only have a matrimonial home and a pension.
Yes.
No other assets. So if Jane is paying her share from the home, and now your client can go and straight away put a down payment on a home.
Mhm.
He's going to get an increase in that property. Look at our real estate market, right? Good and bad. Right? But let's say he invests in a really good time. A year later, he's financially stronger. She's not going to be able. She may not be able to buy a home, and I don't think it's a fair argument that he should go out and buy a home and things like that. They really, if they're starting from kind of the same place, it is what it is. Another way that I could kind of see, because there is cash, there are assets, right? There's her share of the home. So another way to kind of maybe surpass it that maybe we could agree on and agree to settle would be, we don't have to take, just because the family law value of the pension from the pension administrator gives John 50%, he doesn't actually have to take 50%. So if Jane says,
Yeah.
you know what, Anisa, I've lived with this guy for 20 years, very difficult. I know what it's going to take for me to shut him up. I also know if we fight for this, we go to summary judgment motion or a trial or something on it, it costs, it's a lot of change, right? It's a big chunk of change that they're paying to us, which may not be worth it in the end for them. And that's what we do, right? We try to come up with the best scenario.
Yes.
If it's worth it for her to be a little cash poor, and when I say cash poor, I don't literally mean poor, but to take some
Have
from the
less
equity.
cash, yes.
Yeah, to take some of, she's not going to have the liquid cash to deal with, and maybe let's do half from her proceeds of sale or equity in the home, discounted with contingent taxes, and then half at source, right? And then that goes into a lira. That's something that could kind of be that happy compromise.
Yes.
That could work. And then so John he has a 5-year plan. So let's say he just wants to do nothing for the next 5 years. He knows in 5 years he's getting that money. Source, yeah. And then he also has the money that he can go to the casino with, or he can
buy that house.
or buy that house, right? Or pay child support if he really wants to. I don't know.
Okay, so see, these are interesting options, and this is what happens when you involve our lawyers in having these discussions, in helping you craft solutions, right? So we've talked about John and Jane being married. So now, to make this even more interesting, we're going to have John and Jane as a common law spouse, but I'm going to change it up altogether. So now John and Jane have lived together for 5 years, and you'll still maintain your client. So John's still your client, Jane's still hers, and now there's no matrimonial home because they're common law spouses, but there is a family residence. So all they have is that main family residence and the pension, which is owned by Jane. The only thing that's changed, well, 2 things have changed. One is the ages of the children. So the children are now 5 years old and 4. So 4, they have 2 kids still, 4 and 5 years old, and they've been in this common law relationship for 6 years. Jane has a pension. She's still had her pensions for the last 20 years because she's been at the same company. John has no pension.
How old are they again?
Jane is 45 and John is 55.
55?
Yes.
55 now.
Oh, he was 50, right?
He was 50.
Oh no, he is still 50, okay? So John is still 50, Jane is still 45. Jane still has her pension for the same length of time. She's had it for the last 20 years. John still has no pension. And they have a young family despite their age. They're starting fresh, have a young family of 4 and 5 years old, but they're common law in this case, having lived together for 6 years. So now we still have to remember our positions, and I know they're both very well versed in the laws. So I'm going to start off by saying there's no the way it's going to be treated in the law is using trust principles, because the Family Law Act has nothing. It's not as spelled out as division of properties between married persons. So now we have to be engaged in trust principles. So they're very well versed in those trust principles, and that's why we're going to still have. It's going to make their jobs a little bit different now, because Anisa has said not to divide, right? And you're still saying to divide. Okay, so I'm going to start with you, Sherine. Why do you think John is entitled to Jane's pension
Well, John has an interesting position.
Okay.
Given the fact that she had this pension prior to this relationship, so it's going to be a little more difficult for him. Again, because he is a common law spouse, it's not an automatic entitlement, so he'll have to prove by way of an unjust enrichment.
Okay.
So essentially, he'll have to prove that an enrichment or a benefit that is being received by Jane, and he's receiving a corresponding deprivation, which again would be the fact that he doesn't automatically get to share in that pension. Now, I would argue, I mean, I'm not sure what they do, but in this position, I'm going to pretend that he's contributed to the household, he's the main caretaker for the home, and that allowed her to go out and work and accumulate that pension consistently, despite the fact that she's also had this pension for 20 years. He has to now prove a very substantial link to that pension. Now it's going to be a little difficult for him given the fact that she's had this for 20 years.
Exactly.
But again, the fact that he stayed home and they have children only, and that he's cared for these children, and that the fact that he's not able to go out and get his own employment, his own even a pension for himself, that he's only helped her accumulate her pension, so he should be entitled to the portion from the time that they cohabitated to the time that they now separate. So that period of cohabitation, not the entirety of it, but for that period of time.
So you think he's entitled?
He would be entitled. I would argue.
You would argue that he's entitled.
I would
okay.
definitely
So
argue
we could see how now with them not being married, Sherine has recognized that her position is probably a little bit more challenging than it would be. Well, now you have an easier time. Would you agree? I mean, she's only asking for the pension to be divided for just 6 years. So
many things.
So
many things. First principles, obviously no, because when you're in a common law relationship, each of you owns whatever property you brought into the relationship. Whatever you brought in is yours. It's your own money while you're together. If you and your partner, John and Jane, separate, there's no automatic right to divide or share the increased value of any property, including the pension. Because at the end of the day, pension is an asset. It's treated like property. It's a piece of property, and it's not joint. So 2 questions for Sherine, and you don't have to answer them right now, okay? There's 2 questions for Sherine. 1, are you claiming an unjust enrichment or a resulting trust? And for everyone's benefit, Sherine had said it's an unjust enrichment, but both of them are remedies, okay? They're both remedies when it comes to common law couples, especially. An unjust enrichment is the inequitable distribution of the asset after the breakdown of the relationship, okay? And then there are some factors that come to that.
I don't know if Sherine would be able to even claim a resulting trust in this case. So it's a straight out unjust enrichment. I think she's not. So I would have
spoken to that.
I'm going to make this easy for her and say she's not going to argue.
Why not?
Okay, why would you not?
I'll tell you why, because it's the resulting trust is also a remedy which allows married and unmarried spouses whose name is not on title to a property to share the value if it's inequitable not to do so, or inequitable to do so. So I mean, this is only Jane's pension. So again, he's not on this property. So push comes to shove, he doesn't really get anything from it, right? Like if she dies tomorrow, he's gonna have to go and prove that they were together. It'll go to whoever.
But are you even so? Before we get to the remedy stage, So now, do you even think that has Jane even been unjustly enriched because of him being in a relationship with her for 6 years? Do you think there's been any unjust?
Yes and no, because Shirine's position is she's inferred some facts that he's been this caregiver for kids, he's taken on a lot of domestic duties. The way I interpreted it is maybe John doesn't have a pension because he's this big time CEO and he has a financial security blanket at the end, right? Maybe he's part of this company and until he hits year 10 in the company, that's when he'll get his huge payout and he'll walk away with $11 million, right? And maybe Jane's the one that's had to go to work. She had to take the job with the pension. They're both working, and let's even say that grandma and grandpa are taking care of the kids. So now who's really being unjustly enriched here, right?
Well, I can make your argument easier for you, Anisa, because if the law has, and if you review most of the case law, as I know you have, a common thread is you would find that they hardly ever agree to pensions being divided. That's a cell phone ringing, so I will
Stop that.
reviewing the case law. A lot of times, what the trend is, the party that wants to, in a common law situation, the party that's asking for the pension to be divided has to prove a direct contribution. So that is, in your case, I think you even made your life a little bit more difficult. I would actually take the path of least, take the path of least resistance and say, well, it's all well and good. You've helped to the house, but okay, you haven't shown. She said nothing to show how he contributed to the pension, and so she really has.
No, she did.
How did he? Well,
if he stayed home, right? Because she's saying he stayed home and took care of the kids, right? So he did those domestic duties, and that he supported her career. She said those exact words. And if a person made a significant contribution to their
so you're buying that? You're buying
that
I'm
based on the
actually going
layman's terms. No, let me finish.
Okay.
I'm buying that based on the layman's terms of it, right? Because every case is different. So if a person made significant contribution to their spouse's career, common law spouse, okay, and such that it directly helped them increase the value of the pension, okay, they could have a trust claim. But that's bottom line. That's what it is, and that's what, as Jane's
given
lawyer.
6 years though, now we're
Given
talking
6
about
years,
6 years. How significant?
But kids are that wild card, right? Because maybe John had to subdue his career aspirations. Maybe it's the fact that John had a pension up until year 1, right? Maybe they became common. Like I know there's so much, because common law is never straightforward, and there's so many facts, and I know I'm making it a little difficult right now, but I have to consider all that because we don't have this case right in front of us. But equitable claims, bottom line, equitable claims are complicated, okay?
Very.
And that's why you see me in this position, because they are complicated. Each case depends on very particular facts. There's a lot of context that Sherine and I are kind of itching for, and we're going to put in whatever kind of makes more sense for us. But and if you do believe you have a claim in equity for common law, you'd contact an experienced lawyer now.
And that's the key, an experienced one, because unfortunately a lot of lawyers don't have a good grasp on this, on these issues. They are complicated, and the truth is, as you go along, new facts keep coming into play, right? So now he's saying, well, I helped with the children. Well, then find out, you might find out from Jane that they split the child care responsibilities and vice versa. So things like that, or it might be, a factor. I guess the bottom line of this is, it's more, I think, when they're common law, the same fact scenario, you just see how it so quickly changes things, and it's also not as straightforward. Now there's a lot, if you noticed when we were talking about even the with them being married, we weren't thinking of unjust enrichments and facts like who cared for the children and things like that didn't mean that much, because the law has made it straightforward. Its property should be equalized, and unfortunately with common law you have to resort to those principles. I think the weaknesses in Sherine's case is going to be really proving that contribution to acquiring that particular asset, and also the length of their relationship, right? But Anisa is leaving no stone unturned. She's assuming that they're going to be able to prove it, so she's going after every single thing, which is great. That's what you want your lawyer to do. We were trying to get her to take the path of least resistance, but as a zealous advocate, she wouldn't. She's going to go after everything, and she's one step ahead of you. So even before you come up with that argument, she's already trying to tell you that it's not, it's not a great one.
Okay, let's say path of least resistance, okay? No. That's all it is, essentially, right? There's no principle that says that Jane has to share her pension. And part of that could be because maybe when they started living together, she said, well, if I marry you, I'll have to automatically share it. So I'm not going to do that, right? I'm the one that came in with the pension. I contributed 20 years ago. I'm going to keep it. I'm not going to marry you for that. And a lot of common law spouses and common law relationships, couples, they think that, right? They think, well, why would she get part of my cottage, right? Yes. But they're not realizing, well, wait a second, she went up every summer and she helped you with the renovations and stuff like that, right?
She may still have a claim.
There's an equitable claim right there. So it's just things like that. It's very quick, and bottom line is that there are so many equitable claims that go to court that may be dismissed in the end, but at the end of the day, she's still, Jane and company are still going to have to answer them. They're still going to have to address it, and it's very, very fact based. And why I kind of jumped on Sherine, because as soon as she mentioned the kids, I'm like, okay, Sherine and I are on the same page here, because she's referring to case law without really mentioning it. And it comes down to the case law of Kerr and Barano, right, which was the Supreme Court of Canada case, the appeal to the 2011 one.
Yes.
In it also was the Vanass appeal, right, Vanass and Seguin, but it's all referred to as the Kerr and Barano, and we'll link the all cases referred to in the description.
Yeah.
But in that one, I mean, let's even just focus on the Vanass appeal, because that one's actually something that we can actually relate to a little bit more. It was agreed that Seguin, so Vanass was, Michelle Vanass is the common law, well, they're both common law spouses, okay? Vanass, Michelle Vanass and David Seguin. It was agreed in trial, okay, so because this is an appeal, so in the trial stage, Seguin was unjustly enriched by the contributions of Vanass during their 12-year common law relationship. So yeah, it is double the length of the scenario that we have, but for the first 4 years of their cohab, both parties pursued their careers, okay? But in 1997, Vanass took a leave of absence from her employment, and the couple moved to Halifax so that Seguin could pursue a business opportunity. And then over the next 3.5 years, their children were born. Vanass stayed at home. She was that stay-at-home mom. She cared for them, and she performed a lot of the domestic labor. But Seguin worked long hours, traveled extensively for the business. In 1998, Seguin stepped down as CEO of the business, and the family returned to Ottawa, where they were from originally, and they bought a home in both of their joint names. In the year 2000, Seguin received approximately 11 million. That's where I got it from, right? 11 million of shares from his company, from the business. And from that time until their separation in 2005, he actually started engaging more in the domestic chores and childbearing and primary care in that. Then they split the primary caregiving role. So, whereas it was, they were on the same path, then it went unbalanced, now they're back. So the trial judge actually found no unjust enrichment for the first and the last periods of their cohabitation. Okay, so it's just that middle portion, which is where I know Sherine is trying to go with, at least I think so. But the trial judge held that Seguin had been unjustly enriched at Vanass's expense during the period when the children were born.
Okay.
So that's where automatically Jane, well, maybe not, it's not automatic, obviously, nothing's automatic, but that's where my mind is going to, because I know this is leading case law. So as soon as she threw in the kids and that he's taking care of the kids, maybe for that portion, right, Jane will have to split her pension. But Vanass was entitled to half of the value of Seguin's wealth. Okay, and here we're dealing, and I keep saying pension is dealt with just like another piece of property. This one didn't necessarily include a pension, but it is dealing with property. And equitable claims. So Vanass was entitled to half of the value of the wealth that Seguin accumulated during the period of just the unjust enrichment. So not from year 1 to year 12,
Okay.
just from the middle period,
Okay.
less her interest in the home and the RSPs in her sole name. But the Court of Appeal set this award aside and directed that the proper approach to evaluation was quantum merit, which is Latin, and as lawyers, I know we all took a course in Latin, which basically means what one has earned. So they took a quantum merit calculation in which the value of each property received from the other was assessed and set off. So it is complicated, obviously. There's not kind of one approach, there's not one size fits all, but basically in the end, and I'll wrap this up, in Vanass, the appeal was allowed, and the order of the trial judge actually was restored.
Okay.
And that was the correct way to proceed.
Okay.
So that's just a reality of kind of what we're dealing with here.
Okay, so now speaking of that, so let's say we find that, the pension is to be split. With common law, it's not even, we don't know how it's going to be split. So if with the married persons, we know it's equalization, so equal 50-50, so that's pretty straightforward. And if you're seeing how you're already very concerned for Jane, what would you, and let's say you finally, you just hand it to Sherine, or Sherine finally convinces you that, John contributed so much during this 6-year relationship and put everything on the line, and so he should be entitled to share this pension. How much of this pension should he get? I mean, is it fair to assume that John's going to straight out say half, right? So John wants 50%.
Of the pension?
Yes, of the pension in Jane's name.
Sure.
Yeah, let's
Why
do it.
not?
I mean, well, I didn't really, I know that there was a family residence, but I don't know how that's held. So that would determine kind of where I would also go with respect to the pension as well. So if I'm
Okay.
asking for an unjust enrichment, am I asking it on the blanket whole? And then if that's the case, given that they have children, I mean, the length of marriage, the length of the relationship is quite short, so I probably wouldn't be successful in a tri-family venture. But in any case, yeah, I'm not
You're
really
saying
sure
that-
how title is held. What I'm looking, I need maybe more context. would
No,
be nice.
I think no. It's I think that having the title, the family home held jointly, and
Okay.
it's just the pension.
Just the pension. Okay,
That's
that
an
makes sense.
argument.
Okay.
So he's asking.
So then I would be asking for 50%. Yes.
Okay,
I would expect you to ask for 50%.
Okay.
and
I
can
mean,
we
unless you really-
can we expect you to agree to 50%?
Path of least resistance, right?
No.
I mean,
No, I would want to see, and I would put the onus on John to provide why he should be entitled to that 50%.
okay.
Keep in mind, they've only been together for 6 years. She's been contributing to his pension for 20, so I just want to laugh. But
No, but just 50% of the 6-year period.
50% of the 6 years.
Yes, yes,
Oh, okay.
yes.
Yeah,
So I'm
I
taking
still
some of
wanna
the
laugh.
humor from Anisa.
No,
Oh, you still want to
wanna
laugh.
When
Okay.
were these kids born? Hold on. These 6-year relationship, 5 and 4. So maybe for that first year, I would say no. Because
Okay.
what was he doing, right? Why wasn't he there? They weren't married, so he should have. Because we also look at intention, right? What were they doing? Were they sharing everything 50-50? Was it that Jane came in and just started paying for everything, right? Like, was he really reliant upon her? Like, there has to be something that really kind of tilts me to think that John should get part of this. And maybe during those, let's say he was at home with the kids, I mean, yeah, then I would actually put my client's mind to it, depending on how true he is in his claims. I did all this for the kids. I was home. I did this and this. But the minute she tells me, no, Anisa, we did both of them together. I used to wake up at 4:30, make their lunch, put it ready to go, put that love note in their lunchbox, lay out their clothes. All John had to, and then go to work, then come home, still prepare dinner, do this when guests came
So
over.
all he was just sitting there with the kids.
But all he
Yeah,
did
that's-
no. But in John's opinion, let's say he still had to wake up. He still had to pick up the clothes, dress the kids, get them to brush their teeth, feed them the breakfast that maybe Jane had made
You
or
know
laid
what,
out.
Anita, you know why I would
But-
cut this
yeah,
short?
can
Because if
I-
I were a judge, I would say this goes to support though.
Yes.
It doesn't
Mhm.
go to the pension. So for me, it's why John wants 50% of this pension. And all of these arguments we would deal with when we're dealing with
With
the issue
support.
of support.
But that's where I would
Let me
argue
throw a
he may
wrench.
not get
Let
it.
me throw a wrench into your argument. Say she got a very huge promotion through every single period of the relationship,
Mhm.
therefore contributing substantially to her own pension, and her pension only grows in size. And that's again because of the contributions he's made, and through and the fact if they were not together, who's to say that she was able to get that promotion, get that increase in her pension? All of those, I would say she's definitely walking away with a larger portion of assets, and he's going to say, I contributed specifically to the pension. And it's clear because if you're seeing a pension grow from whatever it may be to a substantial size, and the fact that she was able to receive multiple promotions again only shows his contributions, and the fact that there's a financial reward for her at the end. So I mean,
Okay.
that
would-
would be an argument.
That's a solid argument.
It's a good argument. I would look at 5 things. I would look at
Okay.
Yeah, I would look at 5 things,
Number one.
and this is what case law brings us to, right? Because
Okay.
that's what I have to rely on. The first one is the role of the common intention, right? That the resulting trust claims made by, or the unjust enrichment claim made by John. Okay, I look at what was their intention when they became common law partners. Okay, when they decided to move in together, why didn't they get married? Was it because they didn't want to deal with the in-law
Okay.
drama of planning a marriage,
Okay.
or was it that they couldn't afford to get married, or they
Okay.
just don't believe in it?
Okay.
The second one
But would
is
you do this with a 6-year relationship?
Yeah, I feel like, is this a joint family venture? The principles that you're laying out, common intentional mutual
yes,
effort.
yes and no, because now you also have to understand we're in litigation, right? What
I would stop it and say
I'm
you haven't
thinking
even.
she's advanced to it.
She has the audience, and again, my path of least resistance, if I were you, is you're helping her with a lot of her work, and she has some solid arguments. But I would just really sit back and make her do it because
Yeah, the onus goes on her, but this
Yeah.
is what I would look at. It's not that I'm saying I'm putting this.
oh, you're
this
not
is what I
going
would
to
look
argue
at.
it. You're just going
Yeah,
to look at that.
Like, so you're telling me this now. Me in my head, I'm thinking,
okay,
like, what now? What do you have to? Because I have to be real with Jane, right?
absolutely.
If she's got a bottom line is no, right? She can pursue. She can proceed with no on her pleadings as until we hit a trial, right?
Mhm.
And then let the trial judge decide. But in reality, first of all, we look at how much of a pension we're dealing with, right? And how much of the period.
if it's worth,
only,
if it's even worth it,
it's only 6 years. But we're also looking at there's so much that we are looking at, and
So you were going through your list of sort of the factors that you would consider.
I think
for
you were
Jane.
number 2.
So the
Yeah, yeah,
first
I was
one was
actually-
common
so-
intention.
okay. So what was their intention? The second one is whether a monetary remedy for her successful unjust enrichment claim.
Okay.
What is it basically, right? Like what has Jane earned that John thinks he's contributed to? So what amount are you seeking, right?
Oh.
Are you seeking the full 50? So you are
So
seeking the full
50% of the whatever the
Yeah.
pension is.
The third one is the mutual benefit. Okay, so was there any mutual benefit for John or for Jane, right? For them as a relationship, for them as a couple, what is the mutual benefit conferred in the context of your unjust enrichment claim? And I would look at, when should I take it into account for my client? Like, when do I seriously start thinking about that for my client, depending on how successful your claim is going to be? And then the fourth one is the role of the parties and the reasonable expectations, okay?
Mhm.
Because, like I said, right, if they came in and Jane was paying for everything straight away because she was always financially stronger, right? What was John's expectation
Okay,
when
and
that
what's the
relationship
fifth
ends?
one?
And then also kids. And then
Okay.
then the last one, and this comes back to the Kerr appeal, the effective date of the commencement of spousal support. Is he claiming spousal support? And so now we know that he probably is. So
Yeah.
then I look at when he started his claim for spousal support, what his entitlement is for spousal support, how does the pension benefit him, how does spousal support benefit him, is it high range? There's so much.
Okay, so what I'm thinking, so if you put these questions to her and she agrees that, and she's able to successfully answer all of them,
Okay.
we're still back. What would your position be regarding the percentage? Because would you at that point agree to 50%, or would you propose something lower?
Oh, I would definitely propose. So if she's successful, I would propose something lower. If a judge tells us it looks like there's going to be some type of division, I would ask for that period, like what that period is going to be, and I can rely on case law for that. Because the reality of unmarried persons in a domestic relationship, and the problem that we have as lawyers, and the reason why we can't be so straightforward on yes, this will happen and this will not happen, is that in most common law provinces, judge-made law is sometimes the only option for addressing the property, and every case is very specific to their own circumstances, to their own facts.
Okay. What if we throw out 20%? Because you can say, so depending on what answers and with the limited facts that we have, if we can, that's also, so I think that's what I wanted to get to, the
Okay.
fact that John's asked for 50%,
Now he wants
maybe
20?
to avoid, no, he doesn't want 20. You can offer something as an alternate, right? So maybe take 10% of the pension, just so that, because I know you had touched on not depending on how much the pension is and if it's worth it and all that. So if you look at the time and the expense that it would cost, maybe we could just give him 10% and call it a day, right? But anyway, what we've seen from this is how, and Anisa hasn't even, there's a lot more depth in all she said. So I know that it might seem like a lot and it's going over your heads, but that's just the tip of the iceberg. Like, there's still a lot more to dig into. And while, she knows the weaknesses of her case, she's also throwing all of the principles back at John, because she doesn't want John just making the solid argument of his contributions, and he's been there, and it's a 6-year relationship, and he's lost the entire world during this time period, and he doesn't want Jane walking away with it. What Anisa's strategy is to say, okay, I'm going to show you what you need to prove to me if you really want to make this trust claim stick, and you better be willing to come back with all of that. And then I guess maybe here's 10% if we want to call it a day. Now, I'm just saying that for hypothetical reasons, because in real life, I promise you that's not likely. You know, if you're right, you're right, and you don't. But sometimes, depending on the amount, and if you want to compromise that, we can offer a figure, and it's also touched on quantum merit and things like that. We may decide, you know what, maybe your efforts are worth $5,000. We'll give you an extra $5,000 from the sale of the family residence, and not.
But I have to clarify.
Sure,
Sorry,
okay,
I
okay.
have to clarify. What I would want to see
Okay.
is I want to see John's direct contribution
To the.
to her pension.
Okay, good.
Is it because of him that her pension increased? Right? She's getting all these promotions and stuff. Maybe she's just kicked butt in her job, and she's been like that for the last 20
And
years.
I want to end it there because I
Yeah.
think that's a solid point, and that's what this is. Everything is commentary under this, which is what is the main thing that you've done to contribute to this particular asset that you want to share. And all of the factors and all of the points that Anisa has gone through is really to answer this threshold question. Anyway, I'm going to park it here. I have a feeling that we have a lot more to still talk about a pension. So please, leave us comments, send us emails if you want us to expand on this subject. I know it's a lot of information to digest. So thank you for watching this video. We hope it's been very informative. And, if there's other areas on this subject that you want us to expand on, reach out to us, email us, give us a call. And we look forward to hosting another roundtable where we tackle more tough legal questions. Thank you.